Hi, everyone. We're going to start off so we can stay on schedule. I know everyone's still getting their snacks and coming in. So if I can just ask everyone in here to take their seats. And talking about socializing, please, it's no issue if you want to socialize outside, but the sound, even if it's like just a little bit of you, carries because I think it's like the floor. So if you're socializing outside, if you could just go to the carpeted area because it causes just distraction for people sitting at the back to listen to the panelists. So again, no issue with socializing, just making sure you do it on the carpeted side. So we have our next panel is on criminal law consequences in regard to family and immigration law. We have Rubaina Singh of Kim Schofield and Associates, and she'll be moderating the panel, and I will allow her to introduce her panelists. So just turn on your mic. Click on.
Good morning, everyone. So to make sure we cover all areas, this panel is going to be in a question and answer format. So to begin with, let me introduce you to our amazing panelists. Deleta Grandy is a co-founding partner at GDH Family Law. She practices exclusively in the area of family law. John Abrams is a sole practitioner and he practices in the areas of criminal and immigration law. Welcome, John and Deleta. This panel is sort of created on demand because there are a lot of issues that criminal lawyers face in their day-to-day practice as it relates to family law, immigration, and refugee law. So to make sure we are not wasting any more time, I'll go straight to our first question, which is for you, Deleta. When people plead guilty, criminal lawyers often advise that there are collateral consequences, and in particular, immigration consequences. What would you advise are potential family law consequences on any ongoing family law proceedings if a person pleads guilty?
Okay, so I'm going to preface this answer first by making a distinction that I find practitioners in a lot of areas law don't particularly understand because it's new and it's an up and coming piece to family law with recent changes to the legislation. But I find other practitioners use terms like custody and access. So you might hear me say parenting time or decision making. Those are the new terms for those concepts. Okay, so as I'm going through, just keep that in mind. So of course, when an accused or somebody involved with criminal law is going to make a guilty plea, the extent to which that's going to impact their family law matter is going to depend substantially on the nature of the crime, whether or not the person has any children, whether or not they're looking at a sentence that includes incarceration. If we're looking at somebody charged with a more serious crime, where they are facing incarceration, of course, if they're convicted, this is going to completely impact any parental rights that they would have. They are not likely to have any in-person contact with their children. There are some exceptions to this, but very rare. They are likely to be excluded from making any major decisions pertaining to their child's life in any meaningful way. And depending on the length of the sentence, the real world effect of this is that may entirely sever their relationship with their child. Most of the cases that I am involved with, where there's a criminal law component, they involve charges such as domestic assault, uttering threats, harassment. In these situations, incarceration isn't really on the table often, but they will be known to the family court judge and they're absolutely going to be relevant. So it used to be, until March of 2021, that judges had a lot of discretion with respect to how much they might weigh a minor charge or something more historic. But as of March of 2021, there have been amendments to the Divorce Act, which is a federal statute, and the Children's Law Reform Act, which is the provincial statute, which actually include family violence as a factor that judges must consider when making a best interest of the child analysis. And that's the analysis that governs all parenting decisions. So the language is probably going to be not something that criminal lawyers like. It's quite broad. So any violence and its impact on among other things, the ability and willingness of any person who engaged in the violence to care for and meet the needs of the child, and the appropriateness of making an order that would require persons in respect of whom the order would apply to cooperate on issues affecting the child. So that essentially means any violence, this could be something as minor as a very minor, what would be a minor domestic assault to you, that's going to be considered, and judges must consider it. So this is a big change, and it's a very important distinction. I think what might also surprise criminal lawyers is to know that there doesn't need to be a conviction, and family violence doesn't actually have to mean physical violence. The statute provides a pattern of coercive and controlling behavior can constitute family violence. So the definition, of course, is quite broad. The changes are relatively new. They're still working their way through the system. But you know, this has had a significant impact in family law, and it's absolutely something that criminal lawyers need to be aware of as well. So what I would advise is always coordination is key. Coordinate when you have a client who has a family law lawyer or a possible family law action. Coordinate early and coordinate often.
Thank you for that, Deleta. And I'm sure we'll unpack a lot of what was said in our following questions. But initial intake meeting is usually an important meeting where you gather background information about your client. So during the initial intake meeting, what should a criminal lawyer be asking about a person's immigration status for the purpose of pleading guilty? So John, this is for you.
So I think it's key. I think it's really important that you know from the outset what your client's status is in Canada. In my material, I've sort of set out sort of three broad categories. There's Canadian citizens, permanent residents, and everybody else, basically. That's simplified a bit, but I've done that because they're all sort of within those categories. There are certain considerations apply to each one. So for Canadian citizens, well, so first of all, I mean, what I've said in my paper is your first question should be, where are you born? Doesn't necessarily have to be that stark, but I usually try to find out. I usually ask my client, you know, where you're from, and you know, what I want to know is if they've been born in Canada or not, or they've been born somewhere else. If they've been born in Canada, 99.9% they're Canadian citizen. There's some exceptions, but they're very rare. So if they're a Canadian citizen, then you really don't have to worry about them ever being deported or anything like that. But there are some considerations that I can talk about later that do apply to Canadian citizens, including foreign travel. If they're a permanent resident, then any, and what I wanted to say about Canadian citizens is that I've come across probably half a dozen clients in my practice who thought they were Canadian citizens, but turned out they were not. Often children come here with their parents when they're very, very young. They become permanent residents at the first, when they first come here, and then no one ever bothers to do anything about their citizenship. And if they've never tried to get a passport or anything, they often believe they're citizens, but they're not actually. So I've had two clients in my practice who have been here since they were babies, and they've been deported because they got into a series of criminal events to countries that they didn't know at all. And so, you know, even if the person thinks they're a Canadian citizen, dig a little deeper to make sure they actually are Canadian citizens. For permanent residents, any, as I said in my paper, any conviction for any offense that carries a maximum sentence of 10 years or more will make them presumptively inadmissible to Canada and potentially deportable. There's a long process to go through before they might actually be deported, but there's a real danger there if they're permanent residents. For everybody else, and so I'm lumping in students and visitors and people on work permits and refugee claimants, people who have refugee status, or people who are simply out of status. Pretty much any conviction at all is a problem, unless it's a straight summary conviction offense. But as you probably know by now, there's very, very few straight summary conviction offenses in the criminal code. They're almost all hybrid. The Immigration and Refugee Protection Act deems under Section 36 that all hybrid offenses are indictable despite what the Crown elects. So the Crown under IRPA, the Crown election is irrelevant. So for anybody who is not a permanent resident, like people who are on study permits and that sort of thing, a lot of these people, their goal is to become permanent residents eventually. But if they're in university and they pick up a impaired driving conviction or a mischief conviction or something like that, that can wipe out a sort of a whole lifetime plan of staying here. It can make them inadmissible. They may not get their study permit renewed, and then they're gone, and they probably won't be able to come back.
Thank you, John. And Deleta, what about from family law perspective? During the initial intake meetings, what should criminal lawyers be asking with respect to any potential family law matters that the clients may have?
In my experience, I find that when I'm being consulted by somebody, it's typically after criminal counsel has already been retained. And I mean, that makes a lot of sense. The client is addressing what they perceive to be the most immediate need in relation to a recent arrest. So what I would say is very important is to let your client know in the intake process, not to put the family law matter or the potential family law matter on the background, or on the back burner, I should say. I've had a lot of experience where I'm coming into the picture maybe months after there's been an arrest and the client has not seen their children for several months, or there's a lot of financial issues that need to be dealt with. So, in that initial consultation, remind them that there are collateral consequences, there are other issues that need to be addressed as well. And, I'd be advising them to speak with the family law counsel as soon as possible. You're also going to want to know if you're coming in the picture after a family law case has been initiated, you're going to want to know if it has been started as a court action. And as most of you probably know, the reason for that is that family law is very document heavy. It's very affidavit heavy. Pleadings are very long. They're very detailed. And this is all because in family law, it's all about transparency. Tell everything, tell it early, tell it as soon as you can. And that's kind of the opposite of what you guys are, charged to do. So there's a bit of a disconnect there, right, between our respective objectives. So you're going to want to know if you're looking for inconsistencies in a statement of a complainant, particularly if there's a domestic incident. They might have stated facts differently in their family law matter than they have within the formal complaint as part of the criminal process. So I've had a lot of instances where this has happened. I had one case in particular where the parties were separating 2 years after there had been a criminal charge, and the wife in that situation, she had filed an affidavit in strong support of leniency with respect to the criminal matter. And so it works in reverse as well, right? So if somebody in their criminal pleadings is saying he's such a great dad, he's such a great person, and then it's a stark contrast to what's being alleged in the criminal matter, that is of course very helpful to you. And also just factually, right? If they're saying something happened on one day and then in your situation, it's a different day or a different time, these kinds of things can be very helpful. I also want to know if if there's criminal counsel, you also want to set an expectation early to family law counsel and your client that you want to review. So the reverse of that, you want to review anything that your client is going to submit. So I have in my practice, I don't submit court documents unless I've had criminal counsel review them first. And that's to make sure that family counsel is not prejudicing anything in the criminal matter. So there's sometimes a bit of a tug of war about how much gets included. I've been before judges in the family law context where they're saying, Miss Grandy, it's not enough for you to tell me your client didn't do it and he's hired criminal counsel. I need to know more than that. And the criminal lawyer is saying, absolutely not. So it has to be negotiated, right? There needs to be a conference call, you, your client, and the family lawyer, and you need to work out, how can you achieve both objectives to the best degree possible, and how much you might share is of course going to depend upon the severity of the crime and the possible consequences to your client. As anything, your client is not required to admit to guilt of a criminal offense, but it's nuanced.
So oftentimes you're able to convince the Crowns to withdraw or stay the charges against our clients. And withdrawal is obviously the obvious preferred option. But can you comment on what impact can a stay versus withdrawal of charges have on immigration matters, John?
For the immigration context, really all you got to avoid is conviction. So discharges are fine, stays are fine, peace bonds are fine, withdrawals are great, obviously. There are, I'm dealing with one situation now where the fellow he was applying, he's in the midst of a citizenship application, and he's applying, so he's applying for citizenship, and he's just had some very serious criminal charges stayed by the Crown. And under, I forget the section number, but as you probably know, a Crown stay can be like the Crown has 1 year to reenact the charges. So the immigration people are asking me like, well, we got to wait, we have to wait another year, and we're not going to wait. We're just going to dismiss his application. And I'm saying, no, this is no different than a withdrawal, but so that's the only sort of, because as you know, the withdrawal, the Crown can reinstate the charges at any time. But so a stay is actually in some ways better than a withdrawal, but I haven't been able to convince the IRCC of that. So, but that's a very small point, but basically just avoid a conviction. That's all you got to do. It's not that hard.
What about from family law perspective, Deleta? What impact can a stay versus withdrawal of charges have on family law matters?
I wish it was that easy for me. So, in terms of what needs to be disclosed, something that's historic. It's not a criminal. If it's not a criminal conviction, it's not something that needs to be disclosed as part of it's a form 35.1 in family law. It's a mandatory affidavit that has to be completed whenever anybody is making a claim for parenting claims. So you wouldn't have to put it down as a conviction, but by the inherent nature of family law, the other person's probably going to know. So it's going to come out and you're going to have to address it anyway. Keep in mind what I said earlier, family violence under the Divorce Act and the Children's Law Reform Act does not require a conviction. So whether or not somebody is ultimately convicted of the crime doesn't mean there hasn't been family violence. There doesn't even have to have been charges for there to be violence, but that's a problem for me, not for you guys. So what I would say is, practically speaking, whether there's a withdrawal or a stay, from a substantive perspective, I suppose if there's an isolated charge, something minor that was withdrawn, that might lead a judge to not give it so much weight. But procedurally, I think a stay poses similar problems as it does in the immigration context, insofar as a judge is likely going to want to know the ultimate outcome of a matter before granting a final order as it relates to parenting. So a stay is likely going to prolong the family court matter, at least until the expiry of the stay. And sometimes the timelines work out. I mean, in family court, we are quite backlogged in many of the courthouses in the GTA. I mean, I'm booking sometimes 7 months out. So it's not not necessarily too far off from a 12-month stay, but these are the kind of timelines you should be coordinating with. And yeah, in the family law context, they're both going to come out anyway.
So I'll have you here, Deleta. In the context of peace bonds, so if an individual is charged with an offense in a domestic context and they agree to a peace bond, how will that impact any future family law proceedings or child custody matters?
So it's a similar idea. Peace bond, not a criminal conviction, but will come out given the inherent nature of family law claims, particularly if the complainant is the spouse. It's going to be considered an acknowledgement to some degree of conduct that might be relevant to the family violence considerations or the best interest considerations. But where it really is going to be more important is as it relates to the kind of real-time ability of parents to communicate with one another. So, terms of a peace bond will come out as part of the family law proceedings, and then it's sort of the job of a family counsel to navigate around those terms to allow the parties to still, discuss parenting issues, parenting time, communications, important issues about their children. So I think the primary takeaway and advice I'd give to criminal counsel when you're talking, terms of a peace bond is to work that in ahead of time. So make sure you're flagging issues that's going to be relevant for your client once you're out of the picture and they're now living under the terms of that peace bond. So you want them to have what they need in terms of being able to communicate and facilitate time with their children. I think people often, and this often comes up in the parenting context, right? You need to be able to communicate with the other parent to deal with that. But I think what's often overlooked is also the financial issues. So we get a lot of, I see a lot of peace bonds or of release conditions that will say, parties are allowed to communicate through themselves, counsel, or third parties about parenting issues, but it's not dealing with the financial issues. So there has to be communication too about, who's paying for the mortgage, who's paying rent, who's paying the bills. There's these kinds of everyday financial details that have to be worked out as well. Your client might need access to the family home or the matrimonial home to get their belongings. They might need to arrange a time to go there to remove, half of the contents of the home. Like these are all things that need to be considered. So it's good to, again, consult with family law counsel. Do it early and do it often.
So just related to that, but in a different context. So when a client is released on release conditions and there's often no contact condition placed, what can be done on the family law side for the accused to communicate with his children or partner, or any other comments that you may have in this regard?
So we can't do anything until there is an exception carved out in the criminal side. So until we have a change of terms, right? You have to abide by it. So once, in terms of creatively what you can build into those terms, right? Things like using parenting applications, using a third party for communications or for passing documents. The family law side will sometimes carve out a lot of particulars so that it limits the communications that the complainant and the defendant might need to have. So rather than them discussing who's picking up the children from school, it's all clear and it's carved out within the family law plan. So yeah, it's really about making sure that the two documents are allowed to work in tandem together, right?
So John, the next question is for you, and it is related to the expired status. So a person who is criminally charged, but their status has expired, and we see a lot of these instances nowadays where whether it is student visa or work visa, how will that impact their stay in Canada and any potential deportation orders?
It doesn't really matter if their status is expired as far as the criminal law consequences go. There's still, they still become inadmissible for just about any kind of a conviction. So if their status is expired, you know, if it's long expired, then there's probably not much they can do about it. If their status it's expired within the last 2 or 3 months, they have up to 90 days to apply to restore the status. But again, it's just important to avoid convictions. A conviction will sort of deep six any chance they have of restoring their status. So I suppose that's really all I can say about that.
And what about any ongoing refugee claims? So criminal defense lawyers, again, come across clients who are involved in ongoing refugee claims. And if individuals have been denied their refugee claim and they're in the process of appealing it, what impact a criminal charge can have on this appeal process?
So it gets a bit more complicated with refugees, and often you'll ask your client what its status is in Canada, and they'll say that they're a refugee. But by that, they could mean like several different things, and I've sort of set them out in my paper. They could be a refugee claimant, which means they've made a refugee claim and they're waiting for their hearing. They haven't had a decision yet. They could have had a decision, a positive decision, which made them a protected person in Canada. So they have that status here. Or they could have lost the refugee claim and they're in the either in the appeal system or just, you know, they're just basically out of status now, and they've lost all their appeals and they're sort of waiting around for removal. Again, the big there's sometimes other routes for those people to get status in Canada. So again, the big thing is to avoid a conviction. For people whose refugee claims are still pending, it's important to avoid convictions for what we call serious criminality, which is basically any offense that carries a maximum penalty of 10 years or more, which is like, you know, 3/4 of the criminal code, right? So, but that can make them ineligible to make a refugee claim. They still have another way to sort of claim protection, but it's not as robust as an actual refugee claim. So people who have not yet had a decision on their refugee status, it's really important to try and avoid a conviction on a 10-year max offense, if at all possible.
Criminal lawyers often get asked about clients' ability to travel. So I think usually within first, not even 1 week after they get out, they're like, okay, can I just go? Can I go travel somewhere? Can I go somewhere else? Can I go to Europe? Can I go to China? So John, can you comment on the ability of people being able to travel to countries, or if there are any countries, are there any places where you cannot travel, for instance, like United States? Are there any countries this could be an issue, or is it more of like you get a country to country analysis?
So I'll preface my remarks on that just by saying I'm not an expert on U.S. law. I'm not an expert on immigration law in any other country, and that's the country that they're going to is the country that is relevant. So if they really have to know, they should consult an immigration lawyer in the U.S. or in France or in China or wherever they need to go. For Canadian citizens, going to the States is the usual question. They have a very sort of complicated sort of system there, but basically they look to see if you've been convicted of a crime that involves moral turpitude, which is a CIMT. I've given you a list in the materials of sort of the latest case law in the States that I have on what offenses are CIMTs and which ones are not. Generally speaking, if it's not a CIMT, you're not inadmissible to the States, but you have to keep in mind that there's always discretion at the border. For if you're a permanent resident or a foreign national, then where you can go depends a lot, not only on of course what your criminal record looks like, but it also depends on your country of nationality. Because if you're, for instance, if you're originally from Jamaica and you've been a permanent resident in Canada for 30 years, you want to go to the States, you need to get a visa. You can't just go to the States. You need to get a visa from there. So they look at what your nationality is, what your passport is. So it's all over the map. And if your client really needs to know, they have to consult a lawyer, an attorney from that jurisdiction who has specialties in immigration law. I can't tell them, so and neither can you.
So Deleta, I have a few questions for you involving CAS, and I know a lot of criminal lawyers are really curious to know answers to these questions. So when and at what stage does CAS get involved when a person is criminally charged? And are there any particular offenses where they specifically get involved?
Okay, so as you all know, in your practice, anytime the police are called to a residence where there are children present, there is going to be a CAS investigation. So there doesn't have to be charges that stem from it. There doesn't have to be anything that actually results criminally for your client. CAS is primarily an investigative body. When they find reason to take protection steps, then they do so under their purview under the Children's Home Reform Act. With respect to what types of crimes might involve or what might necessitate CAS investigation. So anything that is going to put a child at risk or potentially put a child at risk, or in a place where they might come into harm. It doesn't have to be physical harm. It doesn't have to be something in relation to the child directly. It can be something that's taking place in the environment of the child that they would be exposed to, which would be harmful to them potentially. So generally speaking, if CAS is coming, you know why, and there's usually there's often a history. I'll just say that when there's criminal charges pending, especially in relation with a child, it's usually not a surprise. CAS is reactionary.
And I think this is very important for criminal lawyers. What advice should we give to a client as to whether they should participate in any investigation that CAS conducts, and how that participation in a CAS investigation, i.e. statements admitting abuse of a partner, can affect criminal charges?
Okay, so of course, if your client is looking at possible criminal charges, they have a right to remain silent, but it's nuanced. CAS is not there for you, they're there for your child. So what you don't tell them, they're going to find. So if you're not going to cooperate, they're going to go around you. If you won't let them speak with your children at home, they're going to go to school and speak with your children there. You're not allowed to refuse them to speak with your children. You can request a lawyer be present when they're speaking with your children, but only if your child requests it, not you, and not you through the child. So that would typically happen in the case of older children. So our advice when we're not dealing with a criminal matter from the family law side is always to cooperate. Don't give them more than you need to, but answer the questions, cooperate. If you don't cooperate, there is going to be an adverse inference drawn, and they are going to find the answers to your questions anyway, or sorry, answers to their questions anyway. So the CAS power, their investigative powers supersede your kind of willingness to participate in the investigation. So anything, if you won't sign authorizations, for example, or sorry, if the client won't sign authorizations for CAS to contact third parties, they're going to go and get a court order to allow them to do that anyway. If your client is not going to allow CAS in their home, they're going to get a court order and come back with the police, and they're going to do that anyway. So they're going to find a way around. The best way to go about it is in consultation with someone who practices child protection law in particular, criminal counsel, family law counsel. Speak to the client ahead of time, arrange a meeting for the interview with CAS. Your client is allowed to have a lawyer present. So my advice would be you may want to attend if it's going to be if it's a very serious charge, especially a charge in relation to the children.
So just to follow up on that, so can a statement then a client makes to a social worker in a CS matter be used against them in criminal court? And is a social worker then considered a person in authority?
I think that's actually more a question for you guys. If you're asking, can statements you make to CAS be used against you? The answer is yes. CAS does not owe you a duty of confidentiality if it impacts the protection or potential harm to your child. So how I would describe it is the other parent is not entitled necessarily to the contents of your client's CAS file or investigation if they're in separate homes. But often it will be ordered as part of the family law matter. So a family law judge will say, we need to know, what was happening, what the contents of that CAS file are. So family court judges can order it, and it does become part of the record in family court proceedings. And yes, CAS workers are often witnesses at family law trials and in child protection matters. If CAS is involved and if your client is charged with some serious offenses, particularly those in relation to children, yes, you can rest assured that the worker is probably going to be working closely with the police.
So from what I understand, it's kind of being in a rock and a hard place, because if you say too much, that can be used against you. And if you don't, a negative inference can be drawn from that. So from your perspective, then, how does one navigate protecting rights in criminal court while abiding with CS investigation?
It's about finding that balance. You don't want to be obstructionary, but you don't want to if you remove yourself from the process, right? So depending on the seriousness of the crimes, if you won't cooperate, CAS can actually come in and say, without you being candid with us, without us knowing what's happening, we have no choice but to remove the children from the home, right? Of course, that's the most extreme step that they would take, would be to remove the children from the home, but they're left with no other option if it's a very serious crime that your client is being accused of, and if they're not cooperating. For the most serious crimes, CAS is probably going to be taking steps in that direction anyway, particularly if your client is charged with a crime in respect of the child that's in their home, right? It's likely that they're already not in the same residence. So in terms of what to do, this is where I'm saying, rather than ignore CAS, it's better to set a date and time specifically where you're going to sit down with them. It doesn't have to be in your home unless, they're going to need to do perhaps inspections of the home, but set a time. It could be at the CAS office. It could be at your lawyer's office. Before that meeting, consult with family law counsel, criminal counsel, and the client, and kind of come up with a list of what you can say without compromising the criminal matter too much, but without making it appear that you are being, an obstruction to the CAS process. And what I will always say to clients who might be in this position as well is, you be nice to CAS and let me be the mean one, right? So that when you're dealing with the worker, they're not going to hold it against you so much. They're going to think it's me. So let your lawyers bear some of that burden. That's what I'm saying to clients.
So, John, so that I don't feel you left out. Some questions with respect to application for permanent resident citizenship. So can a person apply for a permanent residence if they have an ongoing charge or if they are on a visa?
They can certainly they can apply, but there's an obligation to disclose if you have any outstanding charges. The questions are very specific. Have you ever been arrested? Have you ever been charged with an offense? Not just whether you've been convicted of an offense. So you have to disclose all that. And so if you've made your application for permanent residence or to extend a visa or anything like that, immigration will know that you've got an outstanding charge. And basically they just won't do anything on your application until they know what's happened with the charges. They'll wait for the outcome. That's basically the way it works. And again, avoid a conviction.
And would these similar, I guess, concepts apply for when people are applying for citizenship as well? Like the kind of answers that need to answer on that application if you're a PR and applying for citizenship?
Yeah, citizenship, it is similar. And again, there's an obligation to disclose any outstanding charges. Again, they will wait for the outcome of the charges. Sometimes they'll wait. Sometimes they'll dismiss the application and say apply again when you're clean. Some things to keep in mind with respect to people who are in the citizenship process is that, or who are wanting to apply for citizenship, is that probation, even pursuant to a discharge, can screw things up for them. You can't count time on probation as residence in Canada for the purpose of applying for citizenship, and you can't take the oath of citizenship while you're on probation. So I've had clients who have applied for citizenship, then they get a conviction, but it's not a conviction that will prevent citizenship from happening. However, they get 2 years with the probation, and IRCC says, well, we're not waiting. We're going to dismiss this one, and you apply again when your probation's over. And that, because the probation was 2 years long, that causes even more difficulties with getting the working up the time in that you need for residency. So so even with a discharge, when around citizenship, probation can be an issue as well. So you sometimes, and it's complicated. So sometimes you probably need to have the person talk to an immigration lawyer before they decide what they're going to do.
So criminal lawyers often give independent legal advice to complainants. And so if a complainant contacts us, Deleta, and advises us that they do not want to proceed with the charges against their partner, and they said things in the heat of the moment, and essentially want to recant, and they want us to reach out to the Crown Attorney about it, would this have any impact on any future divorce or child custody proceedings? And what advice should a criminal lawyer give in such a situation?
Okay, so the short answer is yes. Any change in statement or any inconsistency between a criminal matter and a family law matter is going to call the credibility of that person into question. And if their credibility has been kind of diminished in the criminal sphere, it's possible that now impacts what they're saying in the family law matter. But I think what's very important for criminal lawyers to understand or appreciate, I should say, is that as part of the family law matter, it's not just a matter of saying, well, I'm going to recant what I said. There's cost consequences associated with that. So if you have somebody who's in late stages of litigation and they've spent thousands of dollars on lawyers, and they're approaching later stages of family litigation, which is protracted and quite drawn out, they could be looking at some cost consequences, right? If a pivotal piece of the litigation is tied to that claim. So the advice would be to consult with their family law lawyer about what their potential exposure might be in terms of effect on the substantive claims, but also in relation to costs if they're going to be taking back a very important statement.
And are there any charges that if a client gets convicted of that would have an impact on, in case of married clients, of course, on their divorce proceedings or child custody proceedings and child access?
Yeah, I think I've talked a lot about what we would, call violent crimes, but you're right. There's a lot of charges that are not necessarily violent in nature, but also could have an impact on family law that need to be canvassed early. And, a couple that come to mind would be, for example, DUIs. I've had a client who had kind of an extensive DUI history, and I mean, he was otherwise a good parent. And the solution or the remedy in that situation is to he's still able to have substantial time with his children, but he's not allowed to drive, or he must have someone else drive, or no consumption of alcohol before or during the parenting time. I've similarly had clients who have drug convictions in their past, and they've since gotten treatment and they're gotten rehabilitation, and they're not a present risk. But in order to mitigate against that past or that conviction, there would be terms in a parenting plan saying something similar. So no consumption of drugs before or after. And then what we'll often do is, for a period of time, they might be subject to screenings or tests, right? That's usually not meant to be a permanent measure. It's usually temporary and phase out within a couple of years.
So sentencing is, again, a very important step in a criminal proceeding. So John, as far as immigration law is concerned, what are the best sentences to obtain to lessen the impact of immigration consequences if a client is a permanent resident versus when a client is a student versus when a client is just a foreign national?
Well, I probably you're probably tired of hearing this, but avoid convictions. And the reason I say that is because both the Citizenship Act and Immigration Act speak only in terms of convictions. So those are the only things that promote consequences. So anything else, the discharges, peace bonds, stays, withdrawals, anything else is magic. It's not always possible to avoid convictions. So if you're dealing with a foreign national, like a student or a worker or that sort of thing, a conviction is going to be a problem. And if they're going to get a conviction, and you can't avoid that, then that is going to be an issue, and they're just going to have to deal with it. You can't save everyone. For permanent residents, avoid convictions on 10-year max offenses by any means possible, because that's what triggers the possible deportation. If you can't avoid a 10-year max conviction, try and avoid 6 months jail or more, because that removes their appeal rights. In my paper, I've given you the Supreme Court of Canada case of PHAM, P-H-A-M, that talks about the fact that possible immigration consequences are very much something that a sentencing judge can take into account. They're not supposed to impose an unfit sentence in order to avoid immigration consequences, but they can certainly bend things quite a bit, and they have, in order to avoid some really nasty immigration consequences. So.
So John, is there any difference in being on a probation for a conditional charge versus being on a probation for a suspended sentence as far as impact on immigration is concerned? Because yes, one is one is a conviction and the other is not.
Basically, yeah. So I mean, I mentioned that probation can be a problem for in citizenship contexts, whether it's pursuant to a suspended sentence or a discharge. But basically, avoiding a conviction is always really, really important. One thing I did sort of want to highlight here is that for Canadian citizens, also permanent residents, but for Canadian citizens, one consequence of a conviction, especially for any sort of violence, sexual violence or domestic violence, can cause is that you are not allowed to sponsor anybody for 5 years after you finish that sentence. So if you get if you have a Canadian citizen client, you think, okay, well, this you know, they're going to get a suspended sentence and probation for domestic assault. It's not a big deal. And then they suddenly find out that they can't sponsor their parents for another 5 years until they've, well, 5 years plus the end of the probation. So that's something to keep in mind. A discharge, again, will get rid of that problem, but even for Canadian citizens, sometimes convictions can have consequences.
And John, if I remember correctly, you mentioned if you are on probation, that time doesn't get counted towards your time and stay in Canada for PR purposes. Does the same concept apply for peace bond as well?
No, so it's just with respect to people who are applying for citizenship. So the Citizenship Act says you cannot count as residents in Canada any time spent in jail or on a probation order. It doesn't talk about peace bonds or anything else, so peace bonds are fine. So sometimes, you know, if the the Crown says, okay, we'll give you a conditional discharge, but he's got to go on probation. And so sometimes because they want counseling and maybe protection for the complainant. So one workaround is to try and do the counseling up front, and then look for an absolute discharge with a peace bond to give the protection that the Crown wants. Then you don't have that probation order causing problems with your citizenship application.
And one last question before I move on to Deleta for our last 5 minutes. What are the various immigration consequences of a criminal matter, apart from what we may have already covered?
Is that for John?
Yes, that's for John.
Sorry, just in general, you mean?
Yes, are there things that criminal lawyers should be thinking about? Like we just know the conventional ones, like.
Sorry. Because you asked that, I see a relevant question about conditional sentence orders particularly. So just maybe answering that, because we talked about suspended sentence and that sort of stuff, but on the virtual thing, I see conditional sentence orders and how that is treated for immigration.
Sure. So conditional sentence orders are, well, they're in theory, they're jail for the criminal code purposes, but ever since decision of the Supreme Court of Canada a few years ago, they're not considered jail for the purposes of immigration. It's still a conviction. It's still like probation. If you're on a conditional sentence order, you can't use that time as residency in Canada for your citizenship application. But if you have a permanent resident who's going to get a conviction for any 10-year max offense, say theft over or whatever, and they have the option of doing, 6 months in jail versus 2 years less a day on a conditional sentence, take that conditional sentence, because that will at least preserve their appeal rights. And another thing that I meant to talk about it at a previous question was for Canadian citizens with convictions traveling overseas. I used to be able to tell people, look, you might have problems in the States, but you probably won't have problems anywhere else because they don't know. They have no way of knowing, because the States has access to our CPIC. So they know coming in whether you've got a record or not, but going to Europe and that sort of thing, they don't know. But the European Union is going to implement next year, late next year, a pre-clearance waiver system like we already have, like the states already have. It's a short online application for permission to come into the European Union. But for sure, they're going to have a question on there saying, do you have any criminal convictions? So I don't know yet what the effect will be, but it used to be that people with serious criminal records never really had problem traveling to Europe. But that's going to change, and that could be big. That could be a big consequence for a lot of people.
Tana, do we have any other questions? I'll use that time to answer people's questions.
Yes. So this is for Deleta. So this is a question from online. Someone just asked, do you have recommended wording for contact or parenting time? I guess when we're doing, I assume that means like any sort of bail or probation or anything like that, any orders.
Sorry, just so I understand the question. How should it be worded? Is that
Yeah,
what you're
because
suggesting?
yes.
Okay. So what I find most helpful, and if there can be agreed upon third party to be the facilitator either of contact or communication. So specifically spelling that out. I find sometimes when I'm reading these documents, it's just saying, communication between a third party for parenting access. So how we would frame it in the family law context would be, with sorry, exception would be communication between the parents or through their lawyers or an agreed upon third party for the purposes of facilitating parenting time, contact with the child, something to that degree.
Thank you. And probably a few seconds on. Okay. Great.
Okay, just two quick questions. If you had somebody who was here on a temporary worker student visa that was set to expire in about 3 or 4 months, and they received a sentence with 2 months 2 years probation, will this interfere with their ability to renew that visa when it expires? And a follow-up question, if someone is on probation and their application gets dismissed, is there any prejudice to them reapplying? And would it affect the second application at all, that they were dismissed?
So again, if it's a conviction, whether they got probation or not, they're going to have a problem. If conditional discharge. So no, it shouldn't. If they got a conditional discharge, even though the fact that they're on probation, it shouldn't affect their ability to apply to extend their visa. And I'm sorry, I forget the second scenario. Again, not if they don't have a conviction.
Thank you.
I think we're over our time. We need to clear the stage and make way for the other panel. Thank you, John and Deleta, for being here.